right here, the tension kicks in. A first-degree murder plea is already on the table, which means the judge isn't deciding guilt, only how many decades this man might spend behind bars. Watch how quickly this hearing turns from routine to explosive.
-39417, the state of Texas versus Jacoby Damon Broussard. You, Mr. Broussard?
Yes, sir.
Present with your attorney, Mr. Adams, and the state's attorney.
Yes, sir.
Earlier, you entered a plea of guilty to the first-degree felony of murder in this case. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? State?
I've reviewed it. I have no objections or changes, Judge.
And defense. Then without objection, it's made a part of the record for all purposes here. The agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we really are looking at no less than 5, no more than 30 years confinement in prison. I believe there aren't any other options, correct?
Correct, Judge.
Is that the way you understand it, Langston?
Yes, sir.
All right. Steve, want to go first and last?
I'd like to go last, Judge.
You can go first and last. You can defer. Mr. Adams, go ahead on behalf of Mr. Broussard.
Judge, if you look at page 1 of the pre-sentence investigative report, and I'm looking right above defendant's version, you'll see that it was 3 people that was all charged with murder: Jacoby Broussard, Arthur Small, Charles Moss, and they all were charged with murder. Prior to today, it's my understanding that Arthur Small and Charles Moss has already pled before your court, Judge. And Mr. Helm can correct me if I'm wrong, but I understand that Mr. Small got 8 years, and at that time, Mr. Small was already on probation in your court for another case. And then I believe Mr. Moss, and Mr. Helm can correct me if I'm wrong, I understand he ended up pleading for, I believe, 15 years, 20 years, 15 years, I believe. So what I'm asking, Judge, is if you look, and I'm only looking at page 1, when you look on page 1, Judge, you see specifically where Mr. Thomas was shot at the canal, and then he apparently had got into a fist fight, and I'm reading specifically where it says when he witnessed the fight between Thomas and Trey Moss. Trey Moss was the one who was already in your court, and I believe he took a 15-year deal. He is the one that got into the physical fight with the deceased in this case. And then apparently the deceased came back and there was gunshots. Judge, the thing that we would add to the PSI, and Mr. Helm has already provided this to my office, was the forensic post-mortem examination. And I do not believe Mr. Helm is going to contest that according to Judge, what I was going to tell you is according to the forensic exam, the deceased had a gunshot wound through the right thigh. So he took a bullet to the right thigh. And also it says it was another bullet to the left side of his abdomen.
For anyone watching, this is huge. A 5 to 30-year range means the judge has massive discretion. One wrong statement, one contradiction, and that number can swing hard. And trust me, contradictions are coming.
And that's in this report, Judge. But here you go, Judge. I'll just show that he was shot twice, one to the thigh and then one to his abdomen.
Okay.
So our position
Copy this. Yeah.
So our position, I can make a copy. I can have
Got it.
Oh, so what I'm saying, Judge, is that there were 2 shooters, and we believe to make in line with what my client said, where he said in the defendant's version of what happened.
How many times was the complainant, the victim, shot?
Well, we know he was shot twice because he was,
At least
because one was to the thigh, and that's what I'm looking at right there, and the other one was to the abdomen. So we believe that there was 2 shooters, and with the 2 shooters, and that's revealed, and there was 2 wounds, and I was letting you see where I got that from. It's our position that the wound to the abdomen came from Mr. Moss, and then apparently the wound to the thigh would have been my client, Mr. Broussard. And Judge, if you look specifically, and I'm ready.
Why do you say that?
Because
how can you determine that not being present?
No.
And not having any other scientific evidence to support that other than
because he was there.
Okay, it's what he's telling you.
Right, because he saw everything. He would have been there. And Judge, what I'm saying
So what is it you're saying his responsibility was? What did he do?
what I'm saying with there being with the victim being shot twice, I think, hey, he's a party to offense. But what I was asking judges is that when you look specifically to his criminal history, unlike Arthur Small was on probation when this happened, and he agreed to be a witness for the state to testify against my client. And then unlike Mr. Moss, who's the one that's actually having a physical confrontation with the city, it wasn't my client. And I'm asking if you just read from the PSI, the guy who's the instigator of all of this is Mr. Moss. He's the one that's beating up the man and having a physical fight with him. And he's the one that has more incentive to shoot him than anybody because he got the fight. And our position is that you had two shooters, and that and having two shooters, my client is culpable for firing a shot, but the one who is the most culpable is Mr. Moss. And again, like I said, Mr. Ham can correct me, but I thought, if I'm not mistaken, he received 15 years. I could be wrong, it might be 20, but I know it was not 30 years. And what I'm asking the court is, Judge, is that if the man who we believe is the most culpable got 15, or I know it was no more than 20, then I don't believe my client should get the max out 30 years. And the reason why I'm concerned about that is that, Judge, if you look on page 2, I see where the mother went in there said that she wanted him to get 40 to 50 years in prison, and the dad felt that he should get more than 30. But in my opinion, Judge, in arguing on behalf of my client, the person that was most culpable was Mr. Moss, and Mr. Moss did not get a 30-year sentence. And since he didn't get a 30-year sentence, it's not going to be fair for my client to get hit with 30 years when the man who was most culpable was not. And that's why I showed you, Judge, that it was at least two. There's no doubt, according to the autopsy report, it's no doubt he was hit twice. And absolutely no doubt about that. One to the thigh and one to the abdomen. And I think that my guy is responsible for the thigh, but he's not responsible for the one that went to the abdomen.
No, you've seen the pre-sentence report.
Yes,
He's not responsible for anything.
no, I didn't say that.
That's what he says here.
Okay, but
He's not, he didn't shoot anybody.
no, I hate, and I
So,
think that,
but you're saying he did shoot somebody.
I think that he needs
Is that
to
right?
clarify that. Yeah, he needs to clarify that.
Oh, he does?
Right.
Well, he was pretty clear here in that he pleaded guilty, which was odd, but then he later admits he didn't shoot anybody. That's his inference here. But you're saying he did, even though you weren't there.
I wasn't there, Judge, but the thing is, like I said, the reason why I brought that to your attention, just looking at the autopsy report, to suggest that there was two wounds, and there's no doubt about that.
I'm not surprised.
Pause. The defense is playing a dangerous card here. By arguing there were two shooters, they're trying to slice responsibility, but they risk something worse, confusing the judge. And confusion in sentencing court is deadly for the defendant.
I'm looking at what all this says. It appears as though two people did shoot. That's why two people apparently pleaded guilty.
Right, and it's actually three people charged.
But the pre-sentence report, he's trying to play both sides. I'm guilty, but I'm really not guilty. He can't figure out which one he is, Dr. Jekyll and Mr. Hyde.
And
That's kind of a problem.
that's why I was trying to reconcile his statements with the objective
How do you
data.
reconcile he didn't shoot anybody because he's pleading guilty and he wants to accept responsibility? How does that work? How does it work?
No, I think that he's going to accept responsibility for
But
firing.
that's not what he says here. When he had a chance, he pleaded guilty under oath, but when he went to talk to the probation office and changed direction completely, I mean, being truthful and forthcoming is important. Do you know what happened here? A human being died. A human being, one of God's creatures. You had responsibility with that as well as the other person. But you killed somebody. You feel anything bad about that?
Yes, sir, I do.
Oh, do you? You
Yes, sir.
certainly weren't forthright here at the probation office. You want to just interrupt me?
No, sir.
That's the way you are, isn't it?
No, sir.
I get the feeling you like to control the situation, like you controlled this shooter. You seem to be the boss.
No, sir.
Well, that's the way it looks.
No, sir, you're the boss, sir.
Well, no, that's the way, and that's not the way this pre-sentence report appears. You want to play both sides. I want to make a deal, but I didn't do it. Can't have it both ways.
No, sir.
I'm gonna let you talk in just a second. I want what they have to say.
You ready, Judge?
Yeah, go ahead.
Let me address some of the statements by defense counsel so that we can get on the right page. Mr. Small pled to a lesser included offense of manslaughter and received 8 years TDC. That was all part and parcel of an agreement for him to testify against Mr. Broussard. He stated at the time of this incident and reaffirmed during.
You feel, by the way, you feel like that is fair and appropriate under the circumstances?
Yes, sir.
Go ahead.
He's stated early on and then reaffirmed during trial preparation that Jacoby Broussard is the only person that shot Christopher Thomas on that date. There was a fourth person that was there. All this is a part of discovery. That individual's name is Ladarius, and he's Ladarius Lofton, and he's been cooperating since the incident occurred. He was one of the 4 individuals in the car, and thanks to him, he came forward whenever this body was found and told the Port Arthur Police Department about the fact that this young man was actually killed. Up until that time, they had not seen the bullet wounds in the body. The body was found in the ditch, but they mistakenly believed that it was some kind of an overdose. Had Mr. Lofton not stepped forward, we never would have gotten to the point where a murder investigation would have proceeded. He was not charged. He was present at the time, and he says, again, that it was Jacoby Broussard that was the shooter in this incident. So that's an uncharged individual out of this incident, and the reasons why. Arthur Small was not on probation, as defense counsel said. His agreement is based upon his cooperation. The other defendant, Charles Moss, only entered a plea after Mr. Broussard accepted responsibility. He did that on November 13th. He is waiting sentencing. His agreement was a lesser included offense of a manslaughter. Now, this all goes back to, and the whole reason why we're here talking about a cap of 30 for this individual is that factually, Mr. Adams did get one thing right. There were 2 wounds. There's nothing I can prove that there were 2 shooters. There was, we have firearms reports, and the experts were ready to come forward to show that the 2 wounds that occurred on this came from one gun, not from separate guns. So we know that fits with what the other 2 witnesses were prepared to testify, that puts the responsibility on this man for killing Christopher Thomas on that day. There's no doubt that the facts are that Mr. Moss was involved in the situation. There was a fight between Mr. Moss and Mr. Thomas prior to the incident, but there's no evidence other than this man's suggestion that Charles Moss was a shooter. And I agree with Your Honor, as you always do. You honed in on the fact that he wasn't accepting responsibility. He really hasn't done it today. His lawyer has. He stated emphatically in the PSI report that he was there, but he didn't do it, that it was Charles Moss, shifting the blame over to him. The only thing that's good about that is that him making those kind of statements led to Moss accepting responsibility afterwards, but it doesn't step away from the fact of.
And here it is, the judge catches the contradiction instantly. The defendant pled guilty, but then told probation he didn't shoot anyone. This is the moment the judge's patience starts evaporating. And when a judge feels someone is playing both sides, the sentence can spike.
He killed a man. He killed a man that day. He left him there in a ditch, half clothed, shot in 2 different spots, and he's the one that's responsible for it. His parents are hurting. You can read that. Their wounds and their emotions just come out on the pages where you read what their responses are to this. I've dealt with this family from the very beginning of this incident when it first got indicted, and we learned that unfortunately Mr. Adams represented the decedent before this offense occurred. This family has never been satisfied with how the system has worked in this regard. They did approve the agreement that I made, but it was very reluctant, as you can tell by their statements here. I have no doubt, as I stand before the court, that the man responsible for the death of Christopher Thomas is right before you. He pulled the trigger. It resulted in the 2 wounds. The 2 wounds is what caused that death. The concession to bring it down to 30, as opposed to the cold-hearted killing that it was, has a lot to do with all those facts I was just going through. There was a lot that was going to get muddy at the time of trial. There was going to be blaming on other individuals instead of accepting responsibility. I thought I had it worked out where that was going to occur, and then we get his statements here. That being said, nothing has changed. The facts of the case, which are that Mr. Thomas was shot 2 times with the same weapon. In order for it to occur, as defense suggests, there would have had to have been some exchange between Mr. Broussard and Mr. Moss so that one shoots and then the other turns around and shoots. Is that possible? Yeah, it's possible. But it doesn't change the fact that this is the individual that 2 witnesses says killed that man and left him for dead in the ditch. 30 years is what's appropriate.
Judge, one part that Mr. Hamlin is leaving obvious is that witness, Mr. Smile, has made multiple statements. When he first was approached and gave an interview, he said one thing. Then later on in the case, when the DA's office investigated him, he says another thing. My only point is that Judge Moss, as Mr. Ham stated, has entered into a plea agreement, and he's saying it's coming back for sentencing. It wasn't a 30-year cap on Mr. Moss. And what I'm saying, Judge, is by way of extrapolation and by way of deduction, when you read the first page of the PSI, it was Moss who had a physical fight with this deceased guy. It was Moss that was the one that was throwing blows with him, punching him. That was Moss. And the deceased came back. So if out of everybody there, the guy, in my opinion, that would have been the most heated, the most angry, is going to be the one who had the physical fight. And what I was trying to say, Judge, and that's why I kept pointing out about the 2 wounds, one to the leg and one to the stomach. You had 2 shooters, and that Mr. Moss is going to leave out of here with what, 15 years or something on the cap that he made for Mr. Moss. What I'm saying is that my client should not get 30 when, if you look at his criminal history, to my understanding, Judge, when you look on the last page, he doesn't have that criminal history at all. At all. He does not. And he did go to Memorial High School. He has had employment. And I think, like you said, Judge, it's best for me to, let him do more talking than me. But all I was trying to get the court to see is that there were 2 shooters based upon the wounds, one to the thigh and one to the stomach. Now, I guess the question for you today is do you accept responsibility for the wound to the leg?
Yes, sir. Take for responsibility. Yeah, they know.
And he's taking. So what I want to do, Judge, is to correct and amend the PSI, because what he is saying is what I said.
Does that kill the man? The wound to the leg?
Well, I think that when you if 2 people
Did that kill the man?
I
I take it from your silence, you don't have any answer for that. Yeah. Well, the pre-sentence report, are there any objections to the pre-sentence report?
No, I'm not going to
Then it's made a part of the record for all purposes. According to the authorities that investigated this case, they disagree with you.
Yes, sir.
It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. After he shot Thomas, they left the scene. And then the next morning is when the deceased's body was found in the canal, left to die.
Yes, sir.
And really, both folks who did the shooting here, the defendant and the other co-defendant, have much culpability since they acted together. The just heinous nature of just leaving this person just to die and walking off as though they had a big meal and were going somewhere, watch a ball game or something. It just flippant to treat a human being.
This is the prosecution's knockout punch. 2 witnesses, 1 gun, 1 shooter, and they say it's him. Notice how the prosecutor stays laser-focused on responsibility, not speculation. This is classic courtroom strategy. Eliminate doubt before the judge even considers leniency.
Like that is disturbing, and to change stories through this pre-sentence report, you are not guilty, and then, yeah, but you are guilty, trying to figure a way to manipulate through this without being held responsible. But the investigators who were close to this case and investigated it believed otherwise. Both of you have pleaded guilty. Both of you are responsible for the death of this human being. And the family members are upset that even this limit of 30 years imprisonment just does not seem fair to them. The mother states he should get at least 40 to 50 years in prison. None of them called 911. None of them rendered aid to my son. And he was left there to die, and then to be found later the next day. The father of the deceased, he shot my son, made a choice to do that. He should get more than 30 years. But that is not the maximum. And he is disappointed that, as both of them, that you're not being held for more responsibility to taking their son's life, which was a tragic thing here. Anything else to add by anyone?
No,
I was just asking, just since the other guy who was the fighter did a cap deal that was less than the 30 years, and as to my understanding, that cap was around 15. In comparability, just what I'm saying is that I would ask for my clients to be somewhere around that 15 to 20 years as well.
Through investigation, again, the authorities think otherwise about the responsibility of your client. It was determined that Jacoby decided to fire shots at Thomas, striking him multiple times. That's what they think from their investigation. You weren't there, I wasn't there, but the investigators put this together. He pleaded guilty. The other guy pleaded guilty. They're both responsible. Anything else?
I see what you're deciding.
Mr. Bruce, are anything else you want to add?
I apologize. I'll take full responsibility.
How do you take the life back?
Sure, I wish I can.
Yeah, well, do you think an apology makes a difference to that family?
I sure, and I apologize to the family. It didn't happen. It shouldn't happen.
I guess there's not much they can do about it, but they want their child back. Can you do that?
Sure.
You shouldn't have taken it away from them. Another human being. It's it was our creator who created it, like created you. You have no right to take it away. You understand?
Yes, sir.
You have to pay a price. You pleaded guilty in this case voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years. The judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offense that will be rendered on the judgment. You will be given credit for all time you have served in a direct relationship to this case. This is the sentence. This is what's fair and just. Unfortunately, I just wish there was something in the law we could figure out how we could bring life back. But it is forever when it's taken away, and you were responsible. That is all.
This is where the emotional weight lands. The prosecutor ties the case back to the victim's family, a move judges take seriously when he emphasizes the body found half-clothed in a ditch. That's not just fact. It's framing. A reminder that this wasn't just a fight gone wrong. It was a brutal ending.